On today's documentary of rights and freedoms around the world, we will be talking about Canada. Canada is a country with citizens who take pride in their freedom and rights. But what kinds of rights and freedoms do they actually have? Are they actually the country the world thinks they are? Join me as we delve into the magnificent topic of Canadian rights and freedoms. But before we start, what is a right and what is a freedom? A right is a legal, moral, or social entitlement due to everyone because they are human. Meanwhile, a freedom is the ability to do what one wants without being stopped. The Canadian Charter of Rights and Freedoms was brought into Canada with the new Constitution in 1982 by Pierre Trudeau, a Prime Minister dedicated to bettering the lives of Canadians. These new documents, particularly the Charter, was a much closer step to achieving equality and independence in Canada. The Charter consists of 34 sections, and they all grant Canadians many rights and freedoms, which they all deserve, but with some exceptions and limitations. Let's briefly go over the general idea of what kinds of rights the Charter gives. Section 1 states that the rights in this Charter are guaranteed, but are subject to reasonable and justifiable limits, as stated in the Charter. This section of the Charter creates a lot of conflict because what kinds of limits are reasonable and what kinds are justifiable? Which is why Canadians have Section 33, which issues the Notwithstanding Clause, which gives provincial and federal governments power to pass legislation exempt from Section 2 and Section 7 to 15. Section 2 contains all the fundamental freedoms that Canadians get to enjoy, such as freedom of expression, but are also limited within reason. Section 3 contains democratic rights that tell Canadians that they can vote and when to do so, among other rights that Canadians have over their government. Section 6 contains their mobility rights, which has the obvious, but it also contains something called an extradition, which is surrendering a person accused of a crime to another court. It also has limits on which provinces people can go to because of the economic disadvantage certain provinces may have. Sections 7 to 14 contains all the legal rights, and it is intended for Canadians who get involved with the Canadian criminal justice system. It contains many rights that protect accused individuals from being taken advantage of or mistreated by the police, or even in court in any shape or form. Section 15 contains equality rights that Canadians are entitled to, and they state that they are all equal under the law, and under most circumstances, discrimination is not allowed. An example where discrimination is allowed is when companies take affirmative action, meaning they favor individuals who have been mistreated in the past, such as females, to create more opportunities for them. Sections 16 to 22 talk about the official languages of Canada, and it affirms that Canada is a bilingual country. They speak English and French. And these sections say that both these languages are acceptable in the federal government. The following section, Section 23, protects the minority languages in Canada, mainly French. They give rights to families to have their children taught in the minority language under certain circumstances. Section 24 enforces these rights by stating that Canadians can complain to court if they believe their rights have been violated. Another important aspect of this section is that it protects an individual's privacy by saying that evidence that has been obtained in a way that infringed on that person's rights, that evidence will be dismissed. Sections 25 to 28 covers the rights that minorities have, such as females and First Nations people. Even though all rights stated before applies to them, this affirms it and presents Canada as a welcoming country. The last few sections outlines where and who these rights apply to, and ends off with a citation. The Charter is a big human rights document in Canada, and it applies to all Canadians, and it grants them all freedoms and rights within reasonable limits prescribed by the government. Although all of this sounds amazing, Canada was not always like this. Did you know that in June 2008, Section 67 of the Canadian Human Rights Act was repealed? Section 67 was the only barrier to true equality rights in Canada, as it restricted First Nations people who are protected under the Indian Act to make complaints that were related to the Indian Act. Another barrier to complete equality in Canada has to do with individuals who stereotype and use prejudice. When someone stereotypes, they are creating an oversimplified or overgeneralized judgment or characteristic of a group of people. This type of action usually leads to prejudice, which is like to prejudge someone, to assume things before they actually get to know them. Both of these actions still exist in Canada, and although, as mentioned earlier, they have the right to freedom of expression and belief, these types of thoughts can lead to actions that create inequality. There is evidence that these types of actions exist because minorities, in particular First Nations people, are still fighting for their rights in Canada to be treated as equals. Another barrier to true equality could be the controversy mentioned earlier. As with many cases in the past, the rights of individuals in cases often conflict. For example, a same-sex couple who are in court because a foster home denied their adoption papers can argue that this is discrimination based on sexual orientation or marital status, but the foster home can say that they have the right to freedom of religion or belief. These types of cases can create conflict between both parties and may be a barrier to equality in Canada. How does the Supreme Court solve cases where the rights of both parties are infringing on one another? Should the foster home be allowed to say no because of their homophobic beliefs, or should they give the couple the baby or child? Who decides on the reasonable limits to rights? It all started in 1982 when David Oakes was tried for possession of a narcotic. He appealed that Section 8 of the Narcotic Control Act, which applied the burden of proof on the accused, violated Section 11 of the Charter, which said that an individual was innocent until proven guilty. It was decided that it was a reasonable limit, and the court used this case as a precedent for future cases. To determine the circumstances in which rights can be compromised, they developed the Oakes test, which said that rights can be compromised if 1. The reason to override the right is very important, and 2. There is a rational connection between limiting the rights and the goal of the remedy. The rights must also be limited as little as possible, and if they are severely limited, then the reason must be extremely important. This test has aided the Supreme Court substantially in deciding whether it's reasonable or not to compromise or limit a right. Another way rights are justifiably limited is Section 33, which is the notwithstanding clause. This gives provincial and federal jurisdictions the power to pass legislation exempt from Section 2 and Section 7 to 15. The reason for this was to allow the governments to do acts such as placing criminals in prison, which could be deemed as a violation of rights. Now, what if a Canadian feels that their rights have been infringed on? After all, this is just a piece of paper. It doesn't actually do anything, unless there is an enforcement from the law. Canadians are allowed to file complaints concerning discrimination. Let's say the same-sex couple mentioned earlier wanted to complain for discrimination based on marital status or sexual orientation at the foster home. How would they do it? Depending on where they live, each province has different services and centers for filing complaints. The couple would have to fill out forms and applications, and in them they will have to explain their situation and why they believe it is discrimination. When the Human Rights Commission reviews their complaint, their case may be dismissed if it is not legally convincing. Generally, protected areas are age, ethnicity, color, race, disability, family or marital status, gender, and sex, which can also include pregnancy. They must also experience discrimination in a place operated by the federal or provincial government, such as employment, to qualify to file a complaint. If the Commission believes their complaint is legally convincing, they will ask the foster home, called the respondent in this case, to respond to their allegations of discrimination. They will then both enter a process called mediation, where the same-sex couple and the foster home will try to settle on a compromise. But if the mediation process does not work, the case will be referred to an investigation service. They will gather evidence, create a report, and inform the parties of their findings. Both parties will enter another process called conciliation, where they try once again to resolve their differences. If that doesn't work, that is when they will be referred to an adjudication, a board of inquiry, or a tribunal. They will hear the case and may appeal it for judicial review. Shortly thereafter, remedies will be decided, and usually the remedy would put the complainant in the situation they would have been in if they were not discriminated against. So in this case, the couple would have gotten the baby. If the same-sex couple still feels discriminated against by the final decision, they can contact a provincial. This will mark the end of the documentary. We briefly went over the Canadian Charter of Rights and Freedoms, barriers to inequality in Canada, what constitutes a justifiable or reasonable limit, and how a Canadian can file a complaint. This has been a documentary about the rights and freedoms of Canadians. See you next.